Welcome friends for this fourth part of AEFC. Argue in English fluently and confidently. Yes. After every part and after successful practice of every part, you will definitely comes to know how you are uplifting your skill of arguing. Argument can be done very perfectly or very clearly when your sequence of thinking is proper. You should put your points before the court in proper sequence. If your points are in proper sequence as per the need of that particular court, if you are arguing in trial court, you should show them properly facts after framing issues. What are the chief examination, cross examination, which points. So proper sequence of your argument will lead a greater pleasant to you as well as judiciary also. So judiciary will like your argument. You will be get satisfaction when you argue to the point correctly without going here and there, by keeping the respect of your opposite lawyer also, without any anger, in properly well tuned, well maintained tune of your talking. So such type of thinking are required. And how we can present our case in proper sequence, that is art. We are already observing that cases. In part 1, part 2, part 3, I have given you full bunch for arguing. But in that bunch, I have already teaches you how to argue the case for admission purpose in apex court, Supreme Court. But after admission, when after notice, when both counsels will be there, and before final decision argument, so that argument should have the proper sequence, proper each and every point contains substantial question of laws, reasoning, proper precedent of earlier precedent means earlier case laws of our apex courts, which you want to get it considered by the judges of apex court. You should maintain that. So in any court, whether you are arguing in trial court, whether you are arguing in high court, or whether you are arguing in Supreme Court, so your sequence of talking should be very clearly. And for this purpose, today, I am going to give you the gift of one foreign writer's book. I will show you that book. I will give you that book online, and I will send you by in our WhatsApp group. You download it. And that are the imminent arguments on circumstantial evidences. So how from this side argue, how from other side argue. So we will take some cases in part 5, part 6, part 7. Some cases we will take. So same case, you prepare argument from petitioner side. And to same case, you also prepare argument from respondent side. In civil cases, you can say plaintiff side, defendant side, appellant side, respondent side, petitioner side, respondent sides. So such type of powerful formats of argument on circumstantial evidence, that book I will give you. 200 pages book is there. Our next part is after 1 week. So during this week, you have to read that book. Then find out the difficult words from that book also. So I will give you that. Another thing, new thing I am going to start today from today's part. That means how you can give consultation to your client. When client send you earlier court judgment, after reading judgment, how you motivate your client to file case in your court, which point you can show him. And most difficult part is how you can negotiate among the fees. My junior are always crying, sir, people are not giving us money. And same people are giving 3 times more money to us. Why? That is the style of your explanation, style of your understanding of his problems. How to deal that? So I will show you some judgment. And on that judgment, we will discuss the things. So this is the consultation. In today's part, this part 4, I will not give any one bunch of Supreme Court SLP like that, but which judgment I am showing you today, on same judgment, I advise my client. Then client's case comes to me. Then we file that case in Supreme Court. Then we argue that case in Supreme Court. We admitted that case in Supreme Court. So that full bunch I will share you in part 5 of the same case, which we are going to learn how to advise our client. And obviously, as usual, I will share you 2 best videos. One is the best video of one good High Court, Bombay High Court judge experiences from his scratch to top level. And you will find very good vocabulary in that. Remember, you have to practice daily at least 5 legal new words with its meanings, and by using that in your own sentences. Don't sleep until you finish your minimum work as a legal practitioner. Then sleep only. So keep it in mind and keep it permanently. Even though you become a very good, fantastic, famous lawyer all over India, even though add new vocabulary in your wealth of the language words. So let me start part 4, start with tenses. So now we have to see the perfect continuous tense. In part 1, we saw simple tense, simple present, simple past, simple future. In part 2, we have seen continuous tense, continuous present, continuous past, continuous future. In part 3, we have seen perfect tense, perfect present, perfect future, and perfect past. And now, perfect continuous tense. So, one action is completed and same action is going on. So, suppose I am reading judgment. I have to read 2 judgments as a practice. After reading one judgment, when I start reading another, that means my one action is completed and another action is going on. In such circumstances, you can use perfect continuous tense. So continuous tense ing should be there to verb, and perfect tense have, has, had should be there. So combination of perfect tense and continuous tense should be there in perfect continuous tense. So what is the example of present perfect continuous tense? So we'll take this verb read. The past participle of read is read, read, read. So, and if you are joining ing, that means reading. So, present tense, present perfect continuous tense. I have been reading. We have been reading. You have been reading. You have been reading. He has been reading. She has been reading. It has been reading. They have been reading. So have is there. Ing is also there. So this is the perfect continuous present tense. Then perfect continuous past tense. So instead of have, we have to use had. I had been reading. We had been reading. You had been reading. You had been reading. He had been reading. She had been reading. It had been reading. They had been reading. Remember that. Write on piece of paper. Make proper format. I, we, you, he, she, it, they. Just been. Now, future tense. Future perfect continuous tense. It means in future, one action will be completed and another action will be continued. Very less time we have to use this tense, perfect continuous tense. Mainly we are using simple, continuous and perfect tense. Very rarely we are using in daily life that perfect continuous tense, but that is tense. We should know all the tenses properly. So future will should be there. Perfect tense have should be there. And continuous tense ing should be there. So I will have been reading. We will have been reading. You will have been reading. You will have been reading. He will have been reading. She will have been reading. It will have been reading. They will have been reading. It will has been reading. Sorry. He will has been reading. She will has been reading. It will has been reading. Don't forget, he, she, it has. And I, we, you, and they have. So have should be there. Now we will take one verb and we complete all these tenses. Suppose we will take verb write. Write, wrote, written. So we have to use ing also, and we have to use have or had also, and in future tense we have to will use will, shall also. So present perfect continuous tense. I have been reading. We have been reading. You have been reading. You have been reading. He has been reading. She has been reading. It has been reading. They have been reading. Then past perfect continuous tense. I had been reading. We had been reading. You had been reading. You had been reading. He had been reading. She had been reading. It had been reading. They had been reading. And future tense, future perfect continuous tense. I will have been reading. You will have been reading. you will have been, we will have been reading, you will have been reading, you will have been reading, she will have been reading, she will has been reading, he will has been reading, it will has been reading, and they will has have been reading. Has and have. Has is for he, she, it, and remaining all places have should be. And from next part, from part 5, we are not finishing tenses, but we will take all 12 tenses at a glance by using one verb in this program as an instruction program. And at homework, you are using all 12 tenses, all 12, past, future, present, and each tense 4 parts, at using 5 different verbs at home. So practice that according to. Just read, remember, practice makes man perfect. Only listening and forgetting will not lead towards the expertization in our legal our profession. Our profession is very noble profession. How satisfaction we are getting when we are giving the relief to our client. How satisfaction we are getting. So we are regularly expertising. And when we are losing that case, how we are getting sad, even though we got the money, even though we are not happy that, because our emotions are attached with the client's success and client's failure. We are not there responsible for failure. Our full efforts are towards to get the win of our case. But sometimes facts are not in our favor. Sometimes evidences are not in our favor. Sometimes judges' moods are not in our favor. So sometimes it happens. So next court is there, appellate court is there. You can direct that particular client towards appellate court. Okay. Next part is, as promised, I will give you one very, very good book of arguments. Which book is that? See. Famous legal argument book. I will show you some parts, some pages, and then you have to continue read it at home. I am giving this book by WhatsApp message. Let me see whether it is shared properly or not. Now it is shared. This is scan copy. Cornell University Library. This is a foreign written book. Famous legal arguments. What this book showing? Art, skill, tact, genius, and equivalence. Election. Election means vaktrutva. Speaking art. Election. Your proper vocabulary, proper tone, proper effect of your speech. Okay. Your speech should be properly pleasant. It should be pleasant to audible. It is pleased to audible. So we just can hear that proper. They are getting pleasant, then audience will get the pleasant like that. And when you will get pleasant, you will get happiness. So displayed by our greatest advocates in the more celebrated trials of modern times. So that time. So with several famous cases on circumstantial evidence by Moses Field. So these are the cases. Homicide, the Bond brother case. So index is there. Part 1 also there, part 2 is also there, annoyance, or so you read it properly, preface, and then here we start. Famously argument. Edwin M. Stanton. Argument in defense of Honorable Daniel E. Stickles for the murder of Philip Barton Key. District of Columbia Criminal Court, Washington, D.C., April 1859. So language is a little bit of that particular era. And then on Sunday, February 27th, the city of Washington was suddenly thrown into a state of excitement on learning that Philip Barton Key, U.S. District Attorney, had been shot by Daniel E. Sickles, a member of Congress from New York. The cause of terrible affair was the discovery of a criminal intercourse between Mrs. Sickles and Mr. K, a fact which had been established by Mrs. Sickles' confession to her husband. So these are some facts. Then argument is from here. May it please your honor. So it is a trial court argument. So your honor is using here. So read earlier also. You have to take the printout. Otherwise, you cannot read out on laptop. I think it is very hard to read a laptop because this is a scan copy. This is not regular PDF. Okay. It becomes my duty to present some consideration in support of the points of law which have been submitted by the defense and which points are in conformity with those which may be given a jury. The event which had brought the jury and the prisoner at the bar into the solemn relations and made the court and counsel participators in this momentous trial in the death of Mr. K at the hands of Mr. S, which took place on Sunday, the 17th of February. So how you read earlier facts, you read these arguments, then you read opposite counsel's argument. So this is the perfect piece how to argue in trial court. This right to kill was never denied till now. Some points I'm reading just. What is here given? The counsel resumed his seat. He was greeted with an outburst of applause, which was squared with difficulty. So this can be happen only in trial court because audience are there, general public is there, but it is not happen in apex court. No clap and no applause we are hearing in our court. But in trial court, you can get this pleasant answer. So this is the next case. This is next case. Those who are interested in criminal cases, criminal practice, for them, this book is very, very good blessing. So read the arguments of the stalwarts and try to complete these books before part 5. Already I have tentatively given you the dates of our AEFC part 4, 5, 6, like that. So see that, and before that, try to complete this book. Only 200 pages book is that. So you can easily complete. And whatever you want to read, you can read it. No issue. No need to read all the cases. You can read 1 cases, 2 cases, but try to finish this entire book. And while you are reading, just take the printout of all these 200 pages. That means 100 A4 pages, you have to take the printout and uh, find out the difficult words, underline, write there its English meaning. You can understand it in Hindi, you can understand in Punjabi, you can understand in Marathi also, but write their meaning in uh, English. So thinking process in English should be there. I will show you, I will share you one video on that, how to thinking in English before speaking in English. Many times what happen, specifically for those people who have taken education in vernacular languages, our own languages. Like I have taken my basic education in Marathi medium in up to 10th standard. Somebody have taken the education in Punjabi medium or some Gujarati medium or some Hindi medium, some Urdu medium also. So what happened when we are talking, so when we are trying to initiate our speech or trying to initiate our argument in the court, that time naturally our thinking process is in our language. So we have to convert that language. So first few seconds for few minutes, we have to little bit just the hesitation is there. But after passing that 4 to 5 minutes or 2 to 3 minutes, for me only 1 minute also. So after passing that minute, automatically English thinking to English delivery automatically will get it done. But it requires practice. So my humble request to all of you, before going to bed, stand in front of the mirror and speak in English in whatever subject you want. Whatever subject you want. But if you want to get the mastery on law, to take the subject of law and speak. Speak, speak, speak. And try to use better legal words. First, try to speak whatever low, simple English like that. Then replace that words. I want to take the bail. So this is a simple English. I want to get it granted by from the court. To get granted. To grant. Lordship had granted the bail in favor of my client. Grant. Grant means manjur karna. Manjur kar diya usne. Here they have granted like that. So first use a simple English, then try to replace your better words, and gradually you keep your practice. I am continuously sharing some lectures of Dr. T.Y. Chandrachud for that purpose only. He is a living legend for English language. He is basically Marathi person, but his command on English is very well. He converted educated student. He has taken his doctorate and everything in foreign also. His father was Chief Justice of India at that time. But his vocabulary, you will find new word. He's ready trying to add. So he is today. He may be reading books of good English to add the vocabulary in his language. So when Chief Justice can do that, why we should not do? So we have to. So I will share his more lectures also. Today, I am sharing you one lecture of one eminent personality. I will show you that. Give me a few seconds. Some video links. Justice J. Kathiwala. So I will share you link and I will share, because if I play that lecture here, so unnecessary, we will waste some time in that. Watching that video is not wasting time, but you have that video at your homework, in your homework. You at home, you listen that video and see how that person, see His name is here. Here, link is also there. Okay. So I will directly send you the link. You copy that, keep in folder, keep all these books and everything is in your folder. So how he faces his early days. He don't have the money to survive. And how he gradually grow, how he take the command on the law subjects, how he elevated to the High Court bench of Bombay High Court bench. At the time of elevation of High Court bench, his earning was at that time in crores. Leaving that crores earning and come down to 3-4 lakh per month payment as a High Court judge at that time. So this is a very dashing decision. So how that decision was taken by Justice A.J. Kathwala and how Justice A.J. Kathwala overcome for all this greed to earn more money, because he was already wealthy person at that time. So even though you are wealthy, wealth hunger is always there. But to give something to the judiciary also. So from this side of bench and that side of bench, both sides are very important in our legal jurisprudence. So in legal jurisprudence, no legal matter can be dispensed, can be settled, can be adjudicated without the bar and bench. So we are from bar side and judges are from bench side. So we have to work together to get this. So how Justice A.J. Kathawala worked from the side of bar and then how they turn to the side of bench. So this is a very fantastic journey. I will share you my each and every video which I'm sharing in this program have my vision is there. And I want to create an excellent orator, excellent arguing counsel from you, friends. This is my motto of this program. So definitely you will watch that video, definitely, and obviously find out the difficult word, write its meaning, make the word, yes. And second video is of mine, J.B. Somani, how to search a good advocate. How to search good advocate. That may be in Hindi English lecture. I don't remember whether that lecture is in only English or Hindi English. But I think that may be a Hindi English. If you are comfortable little with Hindi, you can understand it in better way. So how to find the advocate. So that is the one my lecture is also I'm sharing to you today in this part 4. Now our next part. How to guide to clients. How to speak with clients. How to maintain our dignity also. How to manage the rules of Bar Council of India, guiding principle of Bar Council of India. We cannot solicit. We cannot advertise. But some relief they have given nowadays. You can prepare your website. You can add even a website or your specialization like that. You can add some testimonials of your clients. You can add ratings like that. Okay. And you can print visiting card. You can display board like that. So little bit they have done it liberal, but you cannot solicit. You cannot advertise in our legal profession. So when you comes to know if when client calls you, so how to speak with that client? I will give one demo. Demo is that one madam calls me from Punjab side. So, one criminal had undergone for 12 years, 10 years, 12 to 10 years, I think, 10 years. And his appeal was also rejected by High Court, trial court, High Court, Supreme Court. Supreme Court also rejected. But after completing the sentence of only 5 years, he got the suspension of the sentence. So great injustice caused to me because I am victim of that case. Okay, ma'am, don't worry. We are here in Supreme Court to protect your legal right. Ma'am, I will discuss you all in detail, but let me read the order. You send me the latest order in which Judge of High Court has granted him the suspension. And earlier order which they have confirmed his sentences, they have not given their decision, their judgment in favor of that accused, that criminal. So send me both the judgment and other document. If you wish, you can send me PDF files. I want only PDF files, no photo. What happened in photo, friends? Suppose 15 pages judgment is there and they are sending photos. So while they are clicking, photos are in sequence. But while they are sending to us, on their mobile, sequence will be there. But while coming to us, some photo comes first, some photo comes later. So we cannot read that by photos. So I am not accepting any photos. You scan by using scan app and make file, rename that file properly and then send to me. So I can read it properly. So send me this PDF file, ma'am. Thank you. So after an hour or maybe an hour and a half hour, suppose, see, send me that High Court orders, both 2 orders, 3 orders, few more document also. So how to read that and how to advise that client. So that is the main issue of our today's instruction video. So reading the judgment of 70 pages, 100 pages is an art. So for which purpose you are reading that judgment? Now my purpose is to advise to the client and to take that matter in my hand for apex court. So I have to see what is great injustice there and what solution I can give to my client to overcome to that great injustice which my client is causing. So let me share you that orders. I will send you that orders you today. I will send you, I will show you order. Yes, now it is in front of you. Take the printout of all this. Don't read only on computer. See. It is earlier order. The High Court of Punjab, Haryana at Chandigarh. This is a CRM number like that. Date of decision. Nico of alias Sanjeev Kumar. Alias means a token now. The additional name. Petitioner versus State of Haryana respondent. Quorum, judge. One judge is there. Sureshwar Thakur, oral judgment. Now, how many pages this judgment is? I think is two. So 9 pages. So 8 pages is a small judgment. You can easily read total. But I will show you the art to read in short also. Know the facts and know the decisions. That is sufficient to guide the person. So the present petitioner become aggravated from the acceptance of the cancellation report filed by the investigation officer before the learned trial magistrate concerned, qua FIR number so and so, dated so and so, registered at police station, Old Faridabad, District Faridabad, constituting therein offences under section 323, 324, 326, 307, 452, 506, and 34 of the Indian Penal Code, despite a valid protest against its acceptance being raised before him by the present petitioner. The above acceptance was made through an order carried in Annexure P6. Consequently, he is led to throw the instant petition cast challenge thereon. The present petition makes grievance that in the penal incidents which occurred on 25/5/2018, accused Gulshan, Sunny, Geeta, co-accused Gulshan, Sunny, Geeta, Molraj, and Techchand entering his house and thrashing him and causing injuries upon his person. With users of axe, steel spade, cassie, iron rod, and stick had respectively become wielded by each. He also had made averment in the petition that no prompt action upon his motion to the police agencies concerned was taken. So, collectively, these accused have caused the injury to Gulshan, Sunny, Geeta, like that. And to Geeta, one person, Geeta, that injury got serious with axe like that. So that photograph is head injury, then bandage of the hospital, everything we have filed in our petition in Supreme Court. I will share you that petition in part 5. So this case is like this. So under section 156(3) of CRPC, therefore learned trial magistrate concerned and the latter ordering the registration of the petition FIR against the above accused and that police machinery become activated. So FIR has not first taken by the police. So party directly approached to magistrate. Magistrate then accepted that complaint and then give order under this section 2 of CRPC to police, concerned police to investigate the matter. After conclusion of investigation into the petitioner FIR, the investigation officer, that is IO, considered concerned proceeded to draw and also file a cancellation report in respect of the petition FIR. The complainant also filed a protest against its acceptance before learned trial magistrate concerned, and above stated the cancellation report become accepted by the learned trial magistrate concerned, whereas the objection against its acceptance as read by the present petitioner rather become dismissal. Before proceeding to delve into the validity of the challenge as to the order drawn on 12/4/2022 by the learned magistrate concerned, it becomes necessary to bear in mind the factum that in respect of the incident carried in the petition FIR, also an FIR become lodged at the instant of the accused in the petition FIR rather against the present petitioner. The learned trial magistrate concerned, after assuming valid cognizances and jurisdiction thereupon, proceeded to thereon make an order of conviction upon the present petitioner. So after so many dramas, after all, magistrate convict this present petitioner. So magistrate convict this present petitioner, comes to know. So matter filed, petitioner is convicted. Okay. Then why he come here in High Court? To get it acquittal or to reduce his sentence. Okay. So if you have time, you can read more paragraph. Otherwise, go straight away to last few paragraphs. What is the decision of this court? Because we always paucity of time. Paucity means this we don't have the abundant time. So we always read some first two paragraph. We understand what exactly is that. And he get the convicted. Okay. What High Court has taken decision? So in consequence, this court find no merit in the present petition and same is hereby dismissed. Okay. Earlier, one paragraph you can read. Be that it may, the learned counsel of the petitioner also argued that CCTV footage do comprise valid incriminatory evidence against the respondent concerned, but even the above argument fell as the learned magistrate concerned after viewing the CCTV footage has in the paragraph 16 unfolded that the crime incident was not therein clearly visible. Beside, has made observation that there was not sightings in the CCTV footage as purportedly apperent to the relevant incident as to who were the assailant and or as to who was the victim. So that recording of that particular event is not clear like that. In the consequences, this court find no merit of the present petition and the same is hereby dismissed. The impugned verdict of 12/4/2022 as per Annexure P6 as made by the learned trial court is maintained and upheld. So trial court's verdict of the punishment is the same maintained here. After that, this case goes to Supreme Court. Supreme Court also maintain the same sentence. Then that person undergo to the bar. And all of a sudden, already gone to bar, and this is to release after the punishment also, after passing some years also. So, which this particular decision has not affected victim, but latter decision was affected to victim. So let me share that. So we have challenged this particular judgment. This is our impugn order. An earlier order are in sequence. So after when I submit you full bunch, that time you comes to know exactly how we drafted that case and how we put that case. And sometimes what happened? One case we are arguing to get acquittal, and one case we are arguing to give punishment also. So this type of matters we are regularly handling, because in one matter we are from the side of accused, in one matter we are from the side of victims. So this is order under which that person has get the suspension of the imprisonment. So how this order is of only one page. Sanjeev Kumar versus State of Haryana. Sanjeev Gupta, advocate for appellant. Vishal Kashyap. Where is my name here? No, my name is not here, because this is a High Court order. And after getting that order, we take that case, we negotiate fees, everything. Then come advance comes, then we start drafting. What is this order? This is an application under section 389 of CRPC, praying for the suspension of the sentence of appellant Sanjeev Kumar, son of Achraj Lal, in a case registered via so and so FIR in section so and so Faridabad, like that. He was convicted and sentenced as follows. Under section 307, rigorous imprisonment for 10 years plus fine 10,000, and in default of payment of fine to further undergone rigorous imprisonment for 6 months. There are two types of imprisonment. One is simple imprisonment and one is a rigorous imprisonment. Simple imprisonment means खाओ पियो मजा करो, कोई टेंशन नहीं है, खाली अंदर रह रहा है. Hardship is there always. It's not so easy. We have already undergone for that imprisonment in the period of COVID. Continuously, we cannot move ahead like that. So in our house also, we cannot live for a long time at one place. So how these people are? But in rigorous imprisonment, they are regularly taken by the jailers to some rigorous works, to break the big stones into small pieces, sometimes road construction, sometimes this, sometimes that work. So rigorous imprisonment is always giving body pain, and more than capacity, you have to work there. And government is paying you the wages also for that. So while rigorous imprisonment, you are earning also there. I am not telling about the lawyers, you, not for audience, but who is undergone as a rigorous imprisonment. So he can earn also in that. And his boarding, living, so everything is taken care by the state, and deduct that amount also from his wages, and whatever balance wages at the time of his release, final release from the jail, all this balance amount, everything they are regularly giving to the accused. Accused, not that criminal. So one section, one punishment for him is under section 107. One is 326, 7 years rigorous imprisonment, 10,000 fine, in failure of default of payment of fine, more than 6 months. And third, section 506, rigorous imprisonment for 3 years, 3,000 fine, and all the appellant filed by the application was admitted, and recovery fine was statewide order dated 5/7/2019. So this case happened in 2018. Then as per this case, then decision got. Then he undergone in 2019. Counsel for the complainant complainant means Mrs. Geeta, who was victim. But state is appearing always from the side of victim. State is appearing. So in particular cause title, you will not find the name of Geeta here in High Court cause title. Sanjeev Kumar versus state of Punjab and Haryana, like that. So Gita's name is not there. Gita is victim there. State is representing that. Counsel for the complainant has vehemently means forcefully oppose the prayer for grant of suspension of sentence to the appellant. So they oppose to give the grant of suspensions. As per the custody certificate, the appellant has already undergone actual sentences of more than 4 years, 11 months, and 9 days out of the total sentences of 10 years. The appeal of appellant being of year 2019 is not likely to be heard in near future. In view of the above, without commenting on the merit, this is the point. This is the point in the favor of victim. In view of the above, without commenting on the merit of the case, the present application is hereby allowed and remaining sentence of the appellant Sanjeev Kumar, son of Acharaj Lal, is suspended during the pendency of the appeal subject to the furnishing bail bond, surety bonds to the satisfaction of the concerned Chief Judicial Magistrate, Duty Magistrate. So they have given this suspension. So he is released from the jail. So victim gets very disturbed. A person who caused me such type of grievous injury to my head, and he is now on bail, and he get the suspension till his appeal hearing is pending. So this is very, 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 very bad. So from the side of victim, this is from the side of accused, very good thing. So who is coming to you? So victim is coming to me. So after reading judgment, so when the judgment comes to me, I am giving them time. So, okay, I will read it. Please call me at 9 a.m. This is my regular practice, 9 a.m. or in evening, 5 p.m. So, meanwhile, I'm reading that judgment. I'm reading some paragraph. I comes to know what exactly happened here. So, early in the morning, the victim calls me and told me, sir, have you read the judgment? Yes, I have read. Very great injustice caused to you. And High Court has not seen any merit. This is clear-cut line is here. In view of the above, without commenting on the merit of the case, the present application is hereby allowed and suspension is given. After such type of rigorous imprisonment of 10 years, even though 3 sections are there, 10 years, 7 years, 3 years, means 10, 7 plus 3. How much years? 21 years imprisonment. No, this is only 10 years imprisonment. Because all this punishment he have to undergone at the same time. So punishment is of 10 years only. So when any accused is sentenced with punishment of 10 years and after just completing his sentence only 4 years and he gets the release, then how happened to our judiciary? How happened to our public law system? Then criminal don't have any controls. Criminal will ask this suspension of sentence after 2 years, after 3 years. More than 50%, he suppose he is undergoing and then he is asking, so that is a different thing. But before completing 50% also, when asking, is this bad thing? No, don't worry, madam, we will challenge in the apex court. Apex court challenge. Next question of that madam. Sir, what fees? what I have discussed with her, what she got the injustice, and how High Court has done the error while giving the judgment. From earlier order, that full 9-page order, I have come to know the facts and everything about that particular case. I have not discussed with that Gita, because discuss with client only that point which inspired that client. My advocate got my point clear. That is called diagnosis of the problems of the clients. If you diagnose his problem clearly, that time he becomes very happy and trustworthy with you. Then next question, sir, how much fees will you start? So in regular, such type of regular criminal matter, ma'am, I am charging 2 lakh plus 2 lakh. 2 lakhs till SLP get admitted, and 2 lakh after SLP admission till further order. Because this is very hard to admit case in Supreme Court. So we have to work hard on the admission of that particular case. So other lawyer are taking full fees, 4 lakh, but I am taking half here, half there. So you can divide that into 50, 1 lakh for initiating drafting, 1 lakh at the time of filing. Then after filing, admission hearing will be there. And after admission hearing, when case get admitted, notice issue, that time remaining 2 lakh you have to do. But madam, I will not charge you such type of use fees, because you are not criminal. You are a victim. And this is my practice as a lawyer. I am charging very reasonable fees to victim. Very reasonable fees. I will charge you only 1 lakh and 70,000. 1 lakh till get SLP get admission. So 50,000 for initiating drafting, 50,000 for at the time of approval of drafting and at the time of filing of the petition. And after filing petition, when case get admitted, that time after admission till further final order, you have to give 70,000 in 2 installment. After notice 35,000, and after 2 to 3 days, then 35,000. So this done not. I am sending you my wakalatnama affidavit format like that. Oh, today I will share you that exactly what I am sending my client after getting confirmed. She not confirm me, but she pleased with me. And when I'm sending my message, in that message, they can study me, my law firm, my practice, everything. Such type of message should be there. Then account number, then wakalatnama affidavit format, then how I required the documents in PDF format like that. Everything I will send you that message. If I forgot, just remind me. Sir, send the message which you are sending to client. And same way, when you are giving matter for Supreme Court to me, I will share same to you also. And we'll keep your fees in my fees. We will arrange your fees. Today I have got one matter from Bombay High Court, a property matter. So I have dealt that. So I have kept 50,000 rupees of that particular lawyer's fees before admission and 50,000 after admission. So accordingly, I quote that. So I told that advocate, if you got that fees in cash, deduct your fees and send me my fees on account. And if you got that fees directly online to my account, then I will reimburse you your part. So this is clear-cut understanding. This is a professional ethics, and we are dealing in such a way because that lawyer is working hard. Also, he is also working hard. He have to take the copies, scan the proper copies. He have to send me Then I'm sending Wakalatama affidavit format. He is getting it signed. He is getting scan copy. He's working hard there. And additional privilege which I am giving to advocates who are giving cases to me. I'm not soliciting you. I'm teaching you this matter. This video is not a solicitation. This is not open to all. This is only for AEFC students. And this is the part of teaching. Don't share this video to anybody, because these are the secret of our profession. But in every case, we cannot get that money. 50,000 before admission, 50,000 after admission. That is property matter, so I can get. In criminal matter, you have to satisfy in 10,000 before admission and after 10,000, because when I am charging only 1 lakh plus 70,000, okay, that time we can fee according to that. So how much I am charging according to that, yeah. And my 5 lawyers team is working for one case. 2 lawyers are working for drafting, 2 lawyers are working for research, 1 lawyer is working for filing matters, like that. Ready-made, yeah. And all I have to give the proper instruction. I have to keep the track record on that, like that. So people are giving me matter because I have the teamwork. I have the perfection in that. And maybe my books are there. So when I send you the message, in that message, links are there. So through that links, client can study me properly. And then they are thinking. And what happens? Sometimes client is sending advance money immediately till evening and document is also. But every time it not happens. Every time it is not happening. Sometimes client calling to another lawyer, he forgot who is Mr. Somani. Forgot. So after 2 days, just I am reminding. And that is style of reminding. Dignity, you should maintain your dignity. I'm just sending one message. When you are sending the documents, I'm not asking when you are sending the advance payment loan. I'm sending when you are sending the documents, please send your documents as early as possible to initiate drafting or starting drafting process in Supreme Court of India. So he will, he's answering. So till evening I'm sending, but whatever it may be. So like that, we are doing that. So then 50% amount of before admission, 50% amount is coming. Then we are observing that particular record, clear that. Then I pass on that to my team, and then my team is taking care of further care. Then final draft, semi-final draft will come to me. I will observe, I will edit that, I will give instruction to my lawyers to put this question of law, you cut this question of law, put this ground, like that, all that. And then after I am getting satisfied, then I'm sending that client, that draft to client. And if that client is uneducated, less educated, he don't know English, then I'm telling him, go to school in India. Every village have the schools. Go at your village school. There will be an English teacher. Take the printout of this. Go to English teacher. Tell English teacher to explain you this and understand. What happened? When he understand all what is written in this petition, he gets the satisfaction. My each and every point is clear. But this one point is balanced there. So he's telling to that teacher, that one point I want to add this. So he's speaking with that teacher in vernacular language. Teacher translate into English, whatever it may be his weak English, like that. So he's translating that and he's sending that with suggestions. But that one suggestion of less educated client also is very important to win the case. So don't do the ego. I am a lawyer. I know everything. No. Client know everything. You know law. Client know the facts. And the success of lawyership is on the 4 pillar. Success of lawyership is on the 4 pillar. First pillar, know your case facts clearly. Second, know law related to your case. Third, know case laws, citations, which is helpful to you. And fourth, your skill of argument, pleading and argument on this 4 pillar. So first pillar is very important. Facts. So your client, even though he is ignorant, even though he is a thumb impression man, less educated, tell him, approach to any English educated person and get it, understand what I have written. And after 2 days, when I get 1 or 2 point suggestion, we are adding that. Then final draft will be there. Then online. So I will give you the final draft, full bunch of this matter. And then I will tell you how to argue that case. Then you study that. Today, no point is for our argument. But just I am giving you one homework. I have tell you from the perspective of the victim. But you have to think also from this perspective of the accused also. If accused comes to you, then how you interpret and how you explain and how you motivate to accuse. So think on that point and explain that point in front of the mirror. And if you are good preparation, record that audio and drop that audio in our WhatsApp group. So I will read it, I will hear that, I will give marks. From the perspective of Gita also, you clear cut it. From the perspective of victim, my argument is this. From the my advice, and not argument. He's not argument. I'm not giving the homework for argument only. Advice only. From the perspective of the victim, advice is this. And from the perspectives of convicted person, criminal, that is, my advice is this. So we should be both side, from the both side. Yes. How non-vegetarian is bad and how eating non-vegetarian is good also. We have to explain both these sides very perfectly with proper case laws like that. Such type of habit we should have, because anybody can come to us. But in same case, we cannot take the case of respondent. But in another case, when respondent finds you are honest lawyer, because he will try, they are trying to induce me, you're trying to bribe me. Sir, how much money you got from that Gita ma'am? 1 lakh, 2 lakh. I am giving you 3 lakh. Just lose this case. Supreme Court order should not be against me. But I am not doing that. Since my first day of practice till date. Many times, sometimes, chief minister are also calling to us to lose this case. But we are not going. Nobody can move me when I take the case of any person. I have so many experiences. I will share you in later part also. But sometimes chief minister also calling in some political matters, some election matters. But no, Modi also cannot move me. I am the discipline of Dani Palkewal. I am discipline of Acharya Chanakya. I am discipline of Swami Ramdas Swami. But even though they told me lose this case, I will not listen. I am discipline of Vitthal Bhagwan of Maharashtra, Sri Krishna Bhagwan. Even though Sri Krishna Bhagwan tells me lose this case, I will not listen. because to work for my client is my duty. Even though God is coming in front of me and trying to inducing me, I will not get induced. This is not my ego as a lawyer. This is my duty as a lawyer. And when opposite respondents see this and tell him, you feed my number with you. Whenever in another matter you need a very honest lawyer in apex court, you know that I am there. Because after making the taking the huge amount of bribes, you are inducing me, but I not get induced. And many times this type happens. Respondent of this one case, in another different case, they are coming to me also. We should be honest with our profession. I specifically remember, when you are arguing on behalf of the government as a prosecution advocate, that time to maintain this type of honesty is very difficult. Very difficult. Because government is not paying much fee. We cannot charge to accused. And for losing the case when accused is giving the fees, and some people are earning that of monies. But you cannot sleep peacefully. What happened in my regular life, after going on bed within 5 minutes, I got sleep. In last 33, 35 years of my practice, I am satisfied because I am not running after money, friends. Money is running after me. I am only towards my principles of advocacy. I will tell that person, Mr. Sanjeev Kumar, if you want to do compromise some things, just go and meet Gita. If Gita instruct me, then I will think. Because I am liable to only with my clients. So this is the way of thinking, delivering, advising properly, after taking matter, after taking fees, how to deal with the client. No? So everything you will learn in this beautiful course of 16 parts. Now we are in only 4 parts. So friends, we have to stop this sharing and stop this episode also. So let me remind you what we covered in this part 4. First, we covered tense, balanced tense, perfect future, perfect continuous tense in all 3, present, past, and future. Then I have given you one beautiful foreign author's book and foreign learned stalwarts at that time who argued that cases. So that book I have given you for reading that beautiful argument on circumstantial evidences. Thirdly, I have given you one video of former Justice of Bombay High Court to find the vocabularies, to find the difficult word, and to get the good character inside you. And at the time of more than 1 CR practice per month, to left that practice and to become a judge and take monthly salary only 3.5, 4 lakh, whatever it may be. It's very hard decision, but you have taken that decision. So you watch that video, enrich your vocabulary, increase your volume of the words, legal words. Then my video, how to search good lawyer. Who is good lawyer? Huh? Who is good lawyer? Who got the distinction in LLB degree? Is good lawyer. Huh? Good lawyer is that person who diagnoses the sufferings of the client properly. Who diagnose the suffering of the client. What client is suffering, what pain he is feeling, and what exactly solution for his pain. Bas, that lawyer is a good lawyer. How much talented you are, how much brilliant you are, not important in law, legal field. How much emotionally, how much practically you can diagnose that case and give proper solution by maintaining your dignity. Maintaining dignity is very important. When he sent you the High Court order, and after reading immediately you are calling him and discussing, this should not happen. This will not maintain your dignity. Otherwise, he will feel this lawyer don't have the work. He has read my order immediately and he's answering me immediately. No. You send him message. Okay, I will study it today. You call me tomorrow morning. Take sufficient time to diagnose that case properly. Whatever time you have in your hand, you can. Sometimes daily 10 matters are coming to me. But I have to advise that I have to give the timing to different people, different times. So very, very hectic and busy schedule we have with the grace of God, Lord Krishna. Lord Krishna is my Lord. And Lord Krishna's one avatar in Maharashtra is Vitthal Bhagwan. So whatever I am here, I am not there. Because of the grace of God, I am there. Because of their wisdom, because of their planning, I am there. So no, my personal ego is there. This is, I am telling you, just for the sake of the understanding, sake of the knowledge, how we can enjoy advocacy, enjoy reading, enjoy arguing, enjoy research, how we can enjoy. I gradually tell you all these things. And lastly, I have shared you that judgment, how we can advise, how we can do that. So this is the end of today's part 4. Jai Hind, Vande Mataram. Thank you. Thank you very much, friends.